see. I had a, okay, well, welcome to week number 2. We only have 9 more weeks to go. Now, you listen to me saying that, and then you will discover why I say that. And it goes very, very fast, very fast. 9 weeks more we have to go. That is it, and then the quarter will be over. However, though, as I said, if you make sure you refer to the open house that gives you all the parameters, and I'm not going to repeat those things that are in the open house, but the open house lecture is available to everyone, and I'll show you in a few minutes. So let's just go ahead and get started because we got quite a bit of material. We are promptly going to stop at 10 o'clock because I used to go beyond that, but I've decided that I'm going to cut out because then I got to go back and do some grading here. So let's take a look at where we are here. So right now you have on this page the information about who I am at the top. The additional course information, I'm not going to discuss that except to say, hey, Dorian, how are you? Welcome to J150. It's funny, I hope you don't mind me saying it, but I get to meet my students and find out a lot of things. Boy, Dorian found out about me that he's actually from my home. I mean, not just my home, but my neighborhood. He has family that went to the same the grammar school I went to. So welcome. And we also are familiar with many of the pastors that I'm familiar with. So welcome. I like to get to know things about my students because I like to connect with my students. And incidentally, Dorian is now one of many students who've connected with me on Facebook. Again, it's easy to do so. Just go to Richard, Wright. Thank you. I'll put thumbs up. You can see that there. I find myself in a situation where I just stay connected. So Facebook, you could go to Richard Richard Wright, and then space JD. And the JD is for Juris Doctor, my degree. So, and then send me a friend request, and then if I reject it, then send me back a message saying, hey, I'm one of your students. I say, oops, okay. So anyway, again, let's get down here, rubrics. I provided you these rubrics. I encourage you to use these rubrics very carefully. All you have to do to get them here is run your mouse over the highlighted information, copy and paste it at the top in your browser, and it'll take you right to the rubric. Same for the course project and discussion posts. So make sure you use those. I did also send you an email. The second email that you received from me, the first was a welcome email, the second was the rubrics attached. So you have it then right there. Some students forget that where they put that email, so it is now on the home page, and anytime you want, you can go back and look at it. I recommend you use the rubrics as a checklist. And then our live sessions, indicating that last Tuesday we had our open house, and that tonight our live lecture, which is taking place now, and the next one will take place in week 4. You can always plan on your even weeks for your live lectures. And then I include at the bottom, as I will tonight, I have open house recording. If you wanted to also move your mouse on that, but don't do it with the copy and paste part, but just with the link itself, and then copy and paste it, it will lead you to it. I actually convert my my recordings to MP4s, which is neat, and they're uploaded to YouTube, because everybody has access to YouTube. Some people have trouble looking at them when they're on WebEx. A student told me earlier she had trouble looking at the lectures that were on WebEx. I said, well, my lectures aren't on WebEx. They're on YouTube, and you can take the link, and you'll see it in there. It says YouTube, and it gives the numbers and code and all that. So anyway, I encourage you to look at that. I also encourage students to come to the live lectures. So now let's go right over to, we're not going to do these resources. I already did these in the earlier week. So let's go right to our announcement for the week. Constitutional issues and elements of crime. We'll be discussing those. I sent you the PowerPoints earlier. Each week you will get the PowerPoints, and then you have some additional information that I submit that I won't be covering tonight that is like an outline of each chapter. And I give that to my students as a bonus because I want my students to be able to get all the information that they need to help them. Because my goal, as I have stated over and over, and you're going to hear it over and over and over like a broken record, is to achieve student success. That's my goal in every class I teach, and I work very hard and pride myself with that. It's not something extra. It's just something I enjoy doing. I love sharing knowledge with students because someone did it to me, and I'm passing it on, and someday you'll be in the same position and you'll have a chance to. So anyway, chapters 3 and 4 of our text, and then the activity Constitution, elements of crime, which I'll show you, but I won't go over the whole thing. And then highlighted again is our discussion assignment, strict liability crimes. This is I love this particular discussion, and I have a lot of students who some don't think it's constitutional, but it definitely is constitutional. We're going to talk about that tonight during our lecture, so I'm not going to elaborate on it. At any rate, I've looked at some already. I'll be looking at some more tonight after we finish discussion posts, and I reply to at least 2, sometimes 3 a week. And then notice that it's due tonight, the initial post, and then Saturday night, 11:59. Now remember, Central Standard Time. I know that Dorian and I know that Brenna are both in Central Standard, but I have a bunch of students down in Florida, and I have some in Georgia. But make sure that you remember it's Central Standard Time here. And then finally, our written assignment, cruel and unusual punishment. Now, you'll notice that from last week, you not only had a written assignment, but you also had a project. You won't have that project this week, and then all you'll have is the quiz. Now, I'm going to say what I said before, and I keep saying it again. Try not to take the quiz. Resist the urge to take the quiz because it's 10 questions, because you want to go through the material first. Because remember, if you go back to last week and even look at the syllabus to refresh your memory, there is no midterm, there is no final exam. This course is heavily on written assignments. And that's why one of the students asked me one time, and he said, hey, why do we have so many written assignments? I said, well, you don't have a final, and you don't have a midterm. Oh, yeah, you're right. And so our emphasis, and as law, I can tell you, been a criminal lawyer for many years, law is intense and very, 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 very much based upon terminology. And so I'm going to teach you terminology and concepts so that you understand. You won't know it as well as I do, obviously, because it takes years and years, but I'm going to give you some working knowledge stuff that helps you out. So anyway, resist taking the quiz until the very end, because it's only one student asked me if I could give more time on the quizzes. My answer is no, I cannot. The school allows me to, I did one time do it by giving additional 5 minutes, and I didn't get in trouble, but I was told, please don't do that again, because there's a reason for the 10 minutes, and I began to understand, and it made sense. But I was trying to help students, not give an unfair advantage to any student, but now it is something that I have the power to change, but I will not change it unless I'm instructed by the school. There are some people who can get a little more time, but I can't discuss with you how that happens. Anyway, the bottom line is that it's 10 minutes, one question per minute. And then my motto, I already explained it to you. Adversity is a springboard to success. It's a little detailed story I gave to you about myself and my personal life and why that's my motto, and it's contagious. I already had a student who's had some adversity, and I remind them, let's work this together. Let's start strong, let's finish strong, and let's implement that motto in all of our classes, but especially in my classes. So now, before I get to the week's module, I want to get to the course calendar. Give me 1 minute here while I go to that. Okay. Oh, I got everything in there, so I got to get that. Let me get that out of there. I don't want to use because it's too busy. So let's go to the course calendar this way. Let me go back up. Okay, now you'll just see yours. Oh, wow, no, they're all in there. Okay, I got to get them out of there. Excuse me 1 minute while I do that, because you got all of them in here. I don't want them all to show up. Let's get rid of that. These are my other classes. You can see, not as a secret, but it just clouds up the screen. And I do not want to do that for you. Let's see, I got rid of 2. Let's get rid of the constitutional law and critical issues. It should leave just J150. There we go. Okay. So anyway, this color blue here is actually, let me put you back up here. The week that we're in now, it gives your reading assignment. It gives your initial post. It gives your reply post date. Student once asked me, says, but it doesn't tell me much. I says, well, if you click on it, it opens up. And it doesn't give much description about the discussion post, but I gave you a rubric, and the discussion post itself is described within the module. But you want to make sure that you end up completing that. So you're right here. Now, this week we have, I thought the student survey was mid-quarter. I'm moving it. Oh, no, I'm right. I'm right. I'm going down too far. My bad. Here we go. I'm here. That's where we are. I jumped all the way down there. So now we're not that far ahead. It's only week 2. So it gives your posts, and then it tells you, again, your written assignment. Now, just so you'll see, APA format, well, once again, if you use the rubric, you will see that in this written assignment, which is 20 points, if you do not have both citations and references, you will lose 3 points. 3 points. I'm holding up 3 fingers. Hope you can see that. And then run your papers through Grammarly. Some of you, well, I haven't graded your classes yet because I'm going to get them graded by the end of the week. But at any rate, the point of the matter is that be sure that you satisfy the requirements, a cover sheet, citations, and references. And then do an adequate job, and which requires 2 to 3 pages. Now remember, I said this week 1, that was the only written assignment in this class that you're going to have 1 page for. The rest of them are 2 to 3 pages, not counting the cover page, not counting the reference page. 3 facts don't satisfy the requirement. I'm more interested in your critical thinking. I elaborated on critical thinking last week. But please run your papers through your Grammarly. Most of you are familiar with Grammarly. If not, look on the home page. There's some information about it. And if I see that you're having Grammarly problems constantly, I'm going to recommend that you go to tutoring to help you to correct that, because you're going to lose points, big points, away every time. So I'm interested in your critical thinking in your papers. Make that paper a part of your thought process and write the things that you discover about it. So anyway, so you have that one written assignment, the quiz, and the discussion post along with your readings this week. And notice though that the following week, just a little peek ahead, because we're not going to have a lecture during week 3, is that you will have another course project to do. And you follow the parameters that I've laid out for you, again, using your rubric. And then once you get past, this is your week 1 assignments, this is your week 2 assignments, this is your week 3 assignments. Now, if you take a look at your calendar, you will discover something, that once you're through with week 3, you will then have a break from the projects, and you'll have just the written assignments and the quiz until you get to, I think it's week 8. It's 8, 9, 10, and 11. I believe I'm right. But at any rate, you'll see that once you take a look. So that's your course calendar. All right. So use that. You know, if you have a question about a deadline date and you want to know what's going on there with that. Okay. Now let me get out the calendar. And now let's go back to Module 2. Module 2 sets out the assignments for this week. I'm going to be through with that in about 10 minutes or so, because I want to get onto the lecture. I opted to go over the assignments each week to help students, which I usually use for the first half an hour, so that we could make sure. Again, it gives a fact pattern, and it tells you what the question is, tells you the length of the paper, as I already told you also. And as I said here, you do not see the words complete with APA, citations and references. You do not see that here, but I already cautioned you. That's why you got a rubric. That's why you got the rubric. Again, and I'm going to just do this just once to show you what I'm talking about. So when you go to the rubric for your written assignment, you're going to see down here. Oh, that's the wrong tab. I hit the wrong tab. I want to go to course materials. Oh, that's not it. I don't know why I keep saying it's faculty I'm looking for. Let's see. Here we go. It's here. This is what I share with you. Okay. Scrolling down. Okay, this gives you the project. Notice what I just said, just for a peek. Week 1, you did this. Week 3, that's when you have your next project. And then remember I told you, week 8, all the way to the end, you'll have projects. So for week 4, 5, 6, and 7, you will not have a course project. Okay. Now, what I want to refer to is my rubric down here for week 2. Here we go. The length, it tells you, and then it tells you the issues that I want you to cover. You'll get 6 points if you cover this issue adequately, this issue adequately, this issue adequately, and then no spelling or grammatical errors at all. Now, I want you to understand something about this whole thing, is that this rubric specifically does not talk about APA. You'll notice that, and you'll see that. But I take you back to the beginning, and I told you this on the course home. It's a rule. All, see it down here? All written assignments are in APA format. So you're going to lose 3 points off the bat other than what you saw in the rubric if you don't do this. Now, I probably one day will add it to the rubric, but they're getting ready to make some changes, so I'll add it to the revised. So instead, I make sure the word all is included. So you don't have to ask me. If I were you, if I have a professor and I couldn't get them, I would err on putting the APA citations and references in the paper. Get to that as a habit. We want you to get it to that into a habit because it moves toward academic integrity, giving credit for sources that you discovered doing your research. And that's the kind of the mindset that we want to get you going to. All right. And it's also in the syllabus as well. So if somebody says, well, okay, I used the rubric, but it didn't say APA, I said, it's important that you understand that all assignments require APA, all written assignments. Of course, you know, the quiz obviously doesn't because that's not an actual written assignment that you're going to have out. Okay, now let's go back here. I'm only doing this because, like I said again, I take time because I want to make sure that students understand what should be in their papers. So these issues here, 2 to 3 pages, APA citations and references. Okay. Your discussion posts, we won't go over that, and then you have your quiz. Now notice again, this is a time exam, 10 minutes, 1 opportunity. You'll be given a 2-minute warning before the time expires. And so you want to start this without having notes and papers because that'll be a violation of the academic misconduct policy. I had a few students that said over and over that they couldn't get it done in the time, and I know why. And I told the student, I said, you're not supposed to be looking up the answers. You're supposed to know them so you can pick them. Just remember, it's the same kind of concept that you have if you were taking the SAT or the LSAT or any entrance exam to college or those kind of things, standardized tests. You don't have notes. You have to have studied and gotten. That's the same thing here. That's why I encourage you to do it on a Sunday. All right. So with that being said, those are the assignments for week 2. Okay. Now I want to go over the lesson content itself quickly. The objective, we're going to discuss constitutional issues, elements of crime, talk about how crimes are classified. Now, this is where you find information that helps you, explains certain terms. You need to be familiar with these things prior to the quiz so that you can know how to operate. All of these things are going to come into play at some point. And there are some cases that give you what it is. We're going to talk about some of these in our lecture tonight, strict liability. And then you get down here, this is a little activity. And I'm going to take an opportunity to ask a couple of these. Now, a retroactive law that criminalizes an action that was legal at the time it was performed or increases punishment for a criminal act after it was committed. What's the answer? Type it in and I'll see it. Okay, Brenna says ex post facto law. Okay, let's try and see if she's right. Survey says yes, absolutely, correct. And so it tells you, now you know, governmental powers not explicitly stated in that government's constitution, but fairly implied. But fairly implied by it. The answer is in the question. Yeah, that's what I said. Sometimes you need to know that the answer will be right there. It's implied by it. Persons who voluntarily unite with others, they voluntarily unite with others in the commission of an offense. People usually get this one faked out. They get faked out. Which one do you think? Brenda says accomplished. Okay, she's the only one stepping out there. Let's see if she's right. There we go. That's it. That's it. Some people think that accessories before the fact. Uh, so far, see, if this was $50,000 pyramid, so far you will complete it. So let's do the last one on this top line, then I'm going to go and not going to finish. The state of mind to do something prohibited by law without necessarily intending to accomplish the harm that results. Which one? Okay. You say specific intent, maybe. So it's not. That's okay. It's general. I knew it was general. I went with what you said. So anyway, that's it. So anyway, the bottom line is you go through the rest of these. You know, you got these four here. Okay, why not? We'll finish them. Parties whose conduct involve direct participation in a crime. Yep. Yep. That's what you said. So how come it was wrong? That's the principle. Okay, I thought I'd give you that one. I know everybody gets. I laughed because I put the one in there you wanted, but I knew that that was going to kick it out. It's the principle. Parties whose conduct involve direct their principles. Their principles. Yeah, you said accessories before the fact. No, that was wrong. So now governmental, but explain. I explain to you why. I understand your rationale and thinking. You're right. The question says parties whose conduct involved direct, direct participation, and the best answer is, and it is principle. That's what we lawyers would tell you. Governmental power explicitly granted by the Constitution of that government. Yeah, that's kind of like a giveaway there, because the powers is in there too. The mental purpose to accomplish a particular thing prohibited by law, such as the death of another person. The mental purpose. Okay, and you're right. And the last two are easy, because the person who aids or assists another in the commission of an offense, Which one is it? Is it before or after? Yep, you got it. And then the last answer, I don't even have to do it because there's just one left. So anyway, but that's these things, you learn something there. And then you can go back and you can play around with them yourself, um, or you can look at the tape itself. But the point of the matter is, it's more fun when you do this yourself. And I try to do it with the students who attend the lectures. So it helps you to understand some of the principles and concepts. So now, I'm going to stop sharing this and ask you, do you have any questions before I go into the lecture of the materials? Any questions? Any questions about the assignments? You're clear about the requirements? No questions so far. Okay. All right. Very good. All right, so let's go ahead. No questions? Okay, good. All right. So then let's go right ahead and let's get into the lecture itself where I go over the PowerPoints. I usually recommend to you guys that you will have at least printed these PowerPoints up and have them in front of you so that you can take notes on them. It's up to you either way. But the point of the matter is I go through them pretty fast, but because there's so much in here. So I'm going to go ahead and get started. The constitutional limitations on the prohibition of criminal conduct. So what are we saying? What are we talking about? We're saying things that you should not do that could get you in trouble and get you charged with a crime, which will result in you having a criminal record, okay? So now let's go right into it. So early on, you saw this case. It says Marburg, but it means it's really Marbury versus Madison. The author who put this PowerPoint together for us needs to change it. I'm going to see if I can get it, make sure get it amended. I keep saying this all the time, but Marbury versus Madison. It was a famous constitutional law case that I studied way back in law school, and even before that in political science when I took constitutional law. And Marbury versus Madison basically stands for the proposition that the courts are able to review cases and statutes, legislation, and executive orders, and any actions of the other two branches, the executive being the president or the governor in the state, or the mayor on a local basis, or the House and Senate on the federal or state level. And so each are to have a check on the other. But the purpose of the court is to make sure that there is some interpretation given to cases. That is how our law is derived by what the courts do. So it says in our second point, the courts have the power to strike down laws or legislation and other governmental action and determine that something is unconstitutional. For example, let me explain to you. It was once the law of the land, separate but equal. That came out with a Supreme Court case that existed called Plessy, P-L-E-S-S-Y versus Ferguson. Well, in 1954, the United States Supreme Court, in a decision famous in a precedent-setting case, Brown versus the Board of Education, said separate but equal should not be the law of the land. Plessy versus Ferguson stood for the proposition that people could be segregated in terms of education and in case of other things too as well. Then there was some legislation that came after that years later, like civil rights, like 1964. But my point being is that the court changed the laws that existed. There is a famous case that I have in front of me. I was just looking at it on TV, and we'll kind of mention it. I think it's tonight that we mention it, but I know it'll be one of them. It's called Loving, and I'm holding it up so you can see it. But it's about the famous case of Loving versus Virginia. And Loving versus Virginia stood for the proposition that it changed the laws that said that any laws that were on the books anywhere in the United States that prohibited interracial marriage was considered to be unconstitutional. And so as a result of that, that Supreme Court case that this couple took to the Supreme Court with the help of their attorneys and American Civil Liberties Union, that struck down laws that said that. So the court struck down the legislation that Virginia had on its books that said that interracial marriage was prohibited. It became the law of the land with this, just like Brown versus the Board of Education. And so it applies to all state and federal courts. Now, there's what we call unconstitutional per se, which means on its face is unconstitutional, and then unconstitutional as applied. There are some laws that are really unconstitutional on their face, such as now to say that, for example, a person who is of another race couldn't marry another person. And the same thing that happened in the Supreme Court about a couple years ago, which said that males and females could marry each other. And that's what the court said. And so the court has said now that no states can have laws on their books to that effect. So if someone tries to enforce that, then that's unconstitutional per se. Now, if it's unconstitutional as applied, is that, let's say, for example, if there is a law and then the person stops the person from won't follow the law, and it's not applied in a proper fashion. In other words, it's abused and misused, then that's unconstitutional as applied. Okay, so anyway, the bottom line that you need to remember is that the courts interpret the law and decide what the law is. The legislators, House and Senate, enacts the laws. The executive branch applies the legislation and as it's signed into law. But what the legislators can do is they can enact legislation to protect the public health, safety, order, and welfare. And we're going to talk about that in a few minutes. Primarily, they will be using Article 8, which you will become familiar with in this class. U.S. Congress does not possess plenary legislative power. In other words, they can't tell the states what to do, except if it clashes with the federal. If it clashes with the federal, then they can't. So Congress itself, the United States Congress, doesn't control your state's laws. It controls the federal laws, except D.C., which is in there where Congress is, and other federal territories. Okay, and then they deal with enumerated powers. Those are the powers that are written in the Constitution, as you heard discovered from your earlier little test things that we did, where we dragged the answer. And then there are implied powers, powers that fit within the context of the statutes themselves and how they're applied. The Commerce Clause. Now, this is what I was talking about earlier. Controls interstate commerce. It says that economic activity between states is interstate, such as, for example, crossing state lines, or if there's a body of water that is contiguous, like to Indiana. We have one, Lake Michigan, is like Indiana, Illinois, and Wisconsin. And so therefore, interstate commerce, Mississippi River, which runs all the way from Minnesota all the way down to the Gulf of Mexico, operates in the same basis. So any activity that affects the states, the federal government can pass laws. Of crossing the state line to do things illegal. And so example 1 gives an example. Congress cannot prohibit prostitution, but it is a crime to transport a person across state lines for immoral purposes. There's a statute called the White Slave Act. Has nothing to do with slavery as you might think. It is called that, that is the name of it, but it has to do with taking an individual across state lines for sexual abuse. And its power to establish it came from the Article 1, Section 8, the interstate commerce. So Congress has a lot of authority to enact criminal laws by stretching the concept of interstate commerce, such as that's what the Patriot Act is about. That's what the RICO Act is all about, which you're getting ready to write something on in week 3. You'll be dealing with the RICO Act. But the point of the matter is that there are all laws that the federal government does to protect people in various jurisdictions. So the federal government comes in. Usually the feds are involved, the FBI or some other federal agency, but the local agencies sometimes are assisting. Treason is not a big deal anymore because at common law, it was often misused and it says to abuse political dissenters. For example, let me give you an example. Okay, there are people who believe that people who are communists and they want to operate, or they label them communists because they disagree with the mainstream things that are going on, then they could say it's treasonous. I would even go so far as to say that this whole issue about the knee and the flag could possibly have been stretched to apply to treason. However, that would be a violation of the First Amendment, and there's some constitutional issues that we'll talk about in a little while about that. But the fact of the matter is you don't have to be concerned primarily with treason, but just know that in history, it was there, but we don't have a lot of people that are treasonous. Now, you're going to discover some other laws that are in place that are, as we call, cousins to treason, but they're not treason. So the U.S. Constitution sought to limit the power of the government to use treason to punish dissenters, anybody who disagreed with what the government was saying. First, can only be punished for treason if they levied war against the U.S. or in adhering to the enemies of the United States, such as, for example, if you discovered that you were working with Al-Qaeda or ISIS or one of those. Treason would not necessarily be used now because there are other statutes on the books that actually implement the type of things that they deal with under the Patriot Act and acts of that nature. Now, there are two laws that don't exist anymore, but we just tell you the history. One is ex post facto. We already know what that means. It literally means in Latin, after the fact laws. A law passed after an act violates the principle. So in other words, you did something wrong, and then we passed a law, made it illegal, and then you were prosecuted, even though you already did it. Can't do that. Neither are bill of attainders, legislative act imposing punishment without a trial on a person or group of persons. So there is no trial that takes place, no due process or any of that takes place. The right to face accusers, present evidence, to defend yourself, and those kind of things. We don't operate like that. You don't get charged and go right to the penitentiary or to jail or wherever you end up going. Now, there are some differences in how terrorists are handled, but that's a whole different ballgame because of the Patriot Act. But it's not bill of attainder. Bill of attainder would apply across the board to everybody. So basically what we're doing is we eliminate the courts and go straight to jail after we violate the statute. So we don't do that. So you don't have to worry about that. They're both prohibited under the Constitution. So they're not even, this is just a history lesson there, that part. And this is an example where the Supreme Court reversed the conviction of a person for sexual assault on his stepchild. At the time, 1991-92, Texas had a law that stated that a defendant could not be convicted just because on the testimony of a victim unless they were under 14. So this man, Carmel, had been convicted under an amendment to an existing law. The law would stand, but not the amendment. The amendment was ruled to be an ex post facto law because it was after the fact that he committed the offense. And it goes back to what I said about ex post facto. Bill of Rights. Our Bill of Rights consists of the first 10. And so the First Amendment, the main ones, the First Amendment involves freedom of religion, speech, press, and assembly. We're going to talk a little bit about some of those. And then the volatile Second Amendment, we're going to talk about that, not much, but just a little, just a little. That's a hot topic right now because of what happened in Vegas. But it's always a hot topic after one of these terrorists or massacres. Every single one of them, it becomes a hot topic. And then the Fifth Amendment, which the right against self-incrimination. Now, primarily, these laws are what are applied in criminal. There's some others that are in between that we don't spend our time with. But the Eighth Amendment is the cruel and unusual punishment, which has to do with the death penalty generally and or excessive punishment in terms of cases. We determined that we can't prosecute minors because of the Eighth Amendment. We determined that we can't, not prosecute, that we can't give the death penalty to minors, rather, and that we can't give the death penalty to mentally ill persons because of the Eighth Amendment, because it's a cruel and unusual punishment in those situations. The Ninth Amendment are rights that are retained by the people to exist, so we can't pass laws to take away those rights either. Now, the Bill of Rights applies to the states and the state laws because of the 14th Amendment. The 14th Amendment provides the basis for applying the Due Process Clause and the 14th Amendment and applying the rights of the Bill of Rights to the states. So the states can't violate these things either. The Due Process Clause has to do with the fact that you have a right to hearings, you have a right to defense and to face your accusers and those kinds of things. But it's under the federal Bill of Rights that we have those rights that kick in. In other words, these rights here all are applied to the states because of the 14th Amendment, equal protection laws, and violation of due process. Okay, and as I said, due process means what it says. Due process. You have a right to a hearing, a fair trial, speedy trial, and those kinds of things. U.S. Supreme Court, in the Cantwell case, this is a landmark case that said that individuals who were soliciting door-to-door, and these individuals were Jehovah's Witnesses, and they were reaching out to people with their message. Well, what happened is that the state had on its books a law that allowed the conviction of individuals who were doing that. So they were convicted because they didn't obtain approval from the government. Well, the United States Supreme Court way back in 1940 in the Cantwell case says, nope, we can't do this because these people are merely exercising their religious rights and their charitable rights. And they don't necessarily have state authority to have to do that. So the court said that that infringes on the First Amendment. You're going to find that particularly in a lot of cases that involve religion, that the courts will generally do everything they can to step out of the way, except when it comes to a health and safety issue concerning the public. So this is a precedent, not a president, a precedent, P-R-E-C-E-D-E-N-T, not P-R-E-S-I-D-E-N-T, as in the President of the United States, but it is a decision, a court case, which stands for this proposition that the courts don't want to interfere with the religious rights of individuals. This is one of the cases. The First Amendment deals with freedom of speech and press, as most everybody know, but people should understand it's not an absolute. Not all speech is protected. Not all speech is allowed to be given. Oh, I have a right to say whatever I want to say. Well, I'm going to give you some ideas about some things that you might think that are not and should not be because of reasons that it can create chaos and confusion. Some examples are lewd, obscene, libelous. Libelous stuff is something you reportedly write about someone that's not true, knowing that it was, not accidentally, but knowing. If it's not known, then you correct it. That's true. You don't have a problem. But you would if you don't. Profanity, insulting or fighting speech. Now we're going to talk about that a little bit more, and I'm going to give you some distinguishing points about it. There's a thing called the clear and present danger doctrine. That means that things that you say or do present what it says, a clear and present danger to order in the community. Imminent lawless action, back to that same thing, Brandenburg versus Ohio. Now let me elaborate on these right here. In Shank, a 1919 case, the court upheld the First Amendment. The court upheld a conviction, rather, saying that the First Amendment doesn't protect speech that creates clear and present danger. And this is an example of what I was talking about a minute ago. This person had mailed 15,000 leaflets attacking the American participation in the First World War. Now, what happened at that time, it was determined that the morale of the military would be adversely affected. Now, that has changed. That has changed now with some past cases that came down after that. But this was the law in 1919. In other words, that it was clear and present danger to our military forces what this person was doing. Obviously, now people can circulate their own material with their own beliefs and positions, such as what happened in the Vietnam War and some of the wars that have followed since that time. Hess versus Indiana. Now, this is one that I remember when I was in college, we dealt with this in our constitutional law class. It was a pretty recent case then because I graduated in '75 from undergrad before I started law school. The Supreme Court reversed the conviction of Hess, and because the speech, they said, did not constitute imminent lawless action. Now, you might think on its face it is, but they explained why they said it's not. Hess was convicted for yelling, "We'll take the effing road street later," during the anti-war demonstration. Now, he yelled that out. He yelled that out in an open out area. The court said, well, he wasn't directed at any particular individuals or groups, so therefore it wasn't imminent lawless action. The point of the matter is, the more direct to an individual or groups that are present there, the more likely you can find that you could be convicted for imminent lawless action, and it is not protected under the First Amendment for obvious reasons. It creates chaos and danger to people, to the public. Symbolic speech and expressive conduct. See, now we get to the point of the kneeling and all these different things, but here are some of the things that, and the issue about the kneeling, just so you know, the whole argument in a nutshell that they're trying to present is that while those individuals are representing whoever they're representing, the sports team, or if they're in a uniform as a police officer or a military person, that their speech is still present, but it should not be expressed in those situations. You have a right to express it as a private person. However, there's a issue that's still yet to be resolved concerning this issue, and I can see it's explosive in the country. And so, as a result, usually when those kind of things start happening, start priming yourself for what the court, someone will eventually take it up to the court and the Supreme Court. Well, with the direction the Supreme Court is going, it'll be very interesting to see what they decide, because the Supreme Court is more to the right now than it used to be. There are more conservative justices and fewer liberal justices. So we'll just have to wait and see what ends up happening. But it's going to continue to take people to do things to see how far the law goes before it reaches the Supreme Court. It will eventually, I guarantee you. Freedom of expression is a broad concept. Speech, whatever you write, performances, and demonstrations. Peaceful demonstrations can and will be allowed. Symbolic speech includes using symbols. Now, you have to be careful about how you use that symbolic speech. Now, for example, there's a famous case, the Tinker versus is Ohio, I think it is, where armbands were worn to express. Or either, here's another, you ever notice that if something happens to somebody on a team, they'll wear a symbol on their uniforms of that person? Well, that's symbolic speech there. Even wearing the American flag or whatever you wear on your clothes or something, that's symbolic speech. So the First Amendment protects that. The First Amendment also protects the burning of the American flag. Now, listen to this. Some people say, oh, that's un-American. I said, well, you know what? That's an issue for debate, but the Supreme Court said in 1990 that you could burn a flag, but guess what? It better be your flag. You don't burn somebody else's property, because then you not get into flag burning, you get into criminal damage to property and those kinds of things as well. So flag burning can be protected under the First Amendment. It can be. You might not like it, but it can be. That's why people who wear flags, they wear flags, they drape their bodies with it. It used to be an old thing that we were told when we were kids, that you don't fly a raggedy flag. That's a violation of the law. We used to say that if you flew the flag upside down, that you could get in trouble, but that's not true anymore. And that if you had the flag flying at night, no, that's not true either anymore. But the First Amendment versus the maintenance of public order. Here's where we get to the point. Public speech that threatens the public peace can be punished. Now, Cantwell versus Connecticut is an example where the people weren't doing anything except passing out their literature. But if there were fighting words involved, things to instigate, or that how should I say, get people escalated and excited to lead to potential violence, then it's not protected, such as hate speech, obscenity aimed at an individual or organization while they're present. Same with profanity, just like we talked about a few minutes ago. But remember, people say, they say what they want to. You can say maybe disturbing the peace or something like that, but the point of the matter is that people have a right to express themselves in ways. And there are laws on the books that say that you can use the language. For example, like we know now, television now, there's all kind of obscenity and profanity. When I was younger, the laws were different, but that's because the FCC allowed certain things with their regulations that they passed by Congress, because they were dealing with interstate commerce, because it was going across state lines. Like telephones now, internet, and all of these things now, that's why the federal government can be involved in that. Did you know you can make a local phone call to someone and be prosecuted on a federal level because you used a vehicle of interstate commerce? Yes, I just text them, same thing. And with the internet, same thing. So profanity. So now let's go to this famous flag burning case here. Now listen to this one. This person, now you have to be careful about what happens here and how tricky the law can work. I just told you what the 1990 case said, okay? I just told you what the 19 Eichmann case. Now, the year before that case, let me show you something. The Supreme Court in '89 decided that this person who burned the flag at the Republican convention to convey an unpopular message allowed the conviction to stand. But here's what they said. They said the court argued that he was not convicted for the flag burning, but for the message he was conveying. His message is protected under the First Amendment. So the state court said, no. They prosecuted him. But the Supreme Court says, well, no, that's a backdoor way of prosecuting a person for exercising their rights. And so they said, no, that's protected under the First Amendment. And then in 1990, it was clarified again in the other case I showed you. So what am I saying here is that the government will sometimes try to use some other laws to stop that person from getting their message that's unpopular. But the court said that you can't stop the message. But in this case, the court argued that he was not convicted for the flag burning, but rather the message he was conveying, which is bad. Which is bad. Because now his popular message, unpopular message is what you were prosecuting him for, and that's a violation of his First Amendment right. In 1990, they went a little further and included protection of flag burning. So there you understand it now. In 2003, the Supreme Court held that states may punish individuals for burning a cross. And why? The key words, with intent to intimidate. The cross was burned by a guy named Black, who was a Klan member, burned the cross during a rally with intent to intimidate people. In that case, that is not protected because it was intended to intimidate someone, and that is not protectable under the Constitution. They can wear their hoods and other march, but they cannot burn a cross in a situation because it represents an invitation to violence. The Free Exercise Clause of the First Amendment gives a right to peaceful assembly in public places. Now, what the government can do is say, they'll say, okay, you need to do this at a certain time, certain place, in a certain way. And the reason is not to control it, but primarily to provide protection and security adequate enough to protect individuals. For example, some years ago, the Klan or the Nazis wanted to march. It was the Nazis who wanted to march in a primarily Jewish community called Skokie, Illinois. It's a town. And they got a permit to march. And they were allowed to march, but they got the protection and all of that. If you saw the movie, it's an old movie, Blues Brothers, you saw in Chicago that happened in Marquette Park. Well, that was an incident that actually really did happen here in Chicago, where the Nazis were able to march in Marquette Park, and the police provided protection for them so they can express their position. Now, the exception to the free exercise religion, I kind of talked about that area, prohibits religious practices that threaten public health and safety. An example is the Tennessee Supreme Court upheld the validity of a statute making it a crime to handle poisonous snakes in religious ceremonies. Well, poisonous snakes is not good because we have this our religious belief. Now, so what? It's dangerous. So we're not going to allow that. Another, and this just happened recently, where a parent refused treatment for their child. You can refuse medical treatment for yourself as a basis for exercising your free exercise under a religion, under the First Amendment, but not your child. You cannot do that. You cannot do that. Here's a case that fits within a lot of demonstrations. The U.S. Supreme Court upheld the right to peaceful assembly in a public forum. So they said, yeah, you can march in a public forum, because what happened is that some African American college students participated in a civil rights demonstration, and they were prosecuted in South Carolina for doing so as a breach of the peace. Supreme Court says, nah, you're not concerned about the breach of the peace. You're more concerned about what they were trying to present and challenging the laws as the way they were using peaceful demonstration. And so the court says, we're not going to have that because you're not going to infringe on the First Amendment right of those individuals. Here's one that it really doesn't make much difference now. Wisconsin versus Yoder, the Supreme Court said that compulsory school attendance could not be applied to the Amish because it violated their religious beliefs. And so that's a situation that has happened in other beliefs as well. But Yoder settled it once and for all. But to be honest with you, it's a moot point now because now homeschooling is legal and is permitted under the law. One of my sons has been homeschooled for the last couple of years. I have others who attend the public school, but he's one that we've been operating with homeschool, and he's about to graduate from homeschool. But the point of the matter is that compulsory school attendance laws cannot be applied to situations where students are in homeschool programs or because of some religious beliefs. And it's well established that the Amish want to be left alone and operate, and it's based upon their religious beliefs. And every time that would go up into a court, it would lose on the basis of the constitutional right to religion. Now, here's one. This is one of my favorite ones, the Peyote case. The employment decision versus Smith. The Supreme Court rejected the claim that in the ritual religion that peyote was used in the religion. Peyote is a hallucinogen that Native Americans use in their sacramental ceremonies. So therefore, tried to argue that, well, this is our religious ceremony and beliefs. Well, the court said that religious beliefs don't excuse people from complying with neutral laws that apply to everyone. Now, that's an interesting decision. I don't have it in front of me, but I can tell you if you Google it, there is a church that was established near us, our neighbor here in Indiana, called the Cannabis Church. And it's actually a church that they utilize marijuana in their religious ceremonies. Now, it is in a state that is not like Colorado and some other states that have legalized it, but it is in a state where it's not. And so what happened is that this organization got a charter in the state, and they openly said what they do. Now, the problem here is that those individuals who utilize that, when they leave their facility and they are stopped, not because they're leaving facility, because then there has to be some probable cause established, and that's as easy as establishing as driving over the lines a little bit, or zigzagging, or either not using the turn signal, or a tail light being burned out, or something of that nature. Anyway, the point of the matter is that person can be prosecuted then in that case for being under the influence. Now, even in jurisdictions where marijuana is legal, operating a motor vehicle under the influence is illegal. So anyway, my point back here again is that you can't use drugs as saying, "Oh, we're worshiping our God." I said, "Yeah, okay, you might be, but we don't allow the use of drugs in that situation." So it's not protected by the First Amendment in religious. Here's another one. Here's one that a lot of people take offense to: the Church of Lukumi Babalu Aye Inc. versus the City of Hialeah, a 1993 case in which the Supreme Court upheld the right of the Church of Lukumi Babalu Aye, to make animal sacrifices as part of their religious ceremonies. Now, the city itself imposed an ordinance on the church that said to unnecessarily kill, torment, torture, or mutilate an animal in a public or private ritual or ceremony, not for the primary purpose of food or consumption, is illegal. So the Supreme Court said, when it came up to them, this ordinance is unconstitutional that I just read to you because it violates the right of practice of religion. So in other words, they said it's okay to have animal sacrifices, and the Supreme Court allowed it to stand. Now, here's a question I'm going to ask you guys. Do you have any idea why the court took that position? I know the answer, not just from a legal standpoint, but from other things as well. Does anybody, either of you, have an idea about why the court wouldn't touch that animal sacrifices in their ceremonies? Any ideas, questions, comments? Type it in. Okay, you read it in the book. Okay. Do you remember? You have any idea? Dorian, any idea? Okay, he said he takes a little while to type. Can't remember. Okay. Listen to this. Where have you first heard about animal sacrifices? Where you hear? There we go. It's in the Bible, the book that not everybody uses or agrees with, but it's still in the book. In which place in the book? In the what? Yep, that's it, sir. You hit it on the head. It is in the Old Testament, and that is exactly what happened. That's how it's written all the way from Genesis all the way up to Malachi, to the end of Malachi, as to animal sacrifices. So therefore, what these people were doing was merely something that had foundationally been a part of the church historically, and that would be like, man, I know there are animal rights people, but sacrifices came before animal rights people, and it's biblical. So we're not gonna challenge their right. Now remember, they're not using a public facility to promote a position. That's their personal beliefs, and their personal beliefs is based upon what's in that Bible. So therefore, that's why. That is exactly the reason why. I knew this before I even saw it in the book itself, because I, as a minister and as a pastor, I knew. I said, "Oh, this is Old Testament stuff here," and they're not going to attack that. So that's a foundational thing, and that's what that's all about. So that's the deal there. The right to bear arms. Okay, listen to me. We don't spend a lot of time in this class talking about the Second Amendment because there's a lot of conflict. And there's gun control laws in the jurisdiction. Then there are people who oppose, and there are people who are on both sides. There are people who are on one side because of some personal experiences in their families. There are people who believe that automatic weapons and semi-automatic weapons are legal. Well, we know where we are right now with this because of what happened in Vegas a couple of Sundays ago, Sunday before last. But my point being is this: is that the statute, the Second Amendment, right to bear arms, is the phrase that's used to apply it. But I submit to you that the application of it doesn't come directly from that. It comes from the legislative power and authority that is held over legislators, and I say some jurists as well, but legislators first, about from an organization called the NRA, or the National Rifle Association. It's very political. I teach constitutional law, which is one of the classes that I am teaching this quarter. And I have 1 week that's all about the Second Amendment. That's where you'll hear me elaborate on it in detail. But just be aware that there's a conflict, and it depends on what jurisdiction you're in. For example, Illinois was the last jurisdiction to adopt carry conceal. And now that all 50 states have carry conceal, some states have carry open, which means people are walking down the street with their guns. It's like the Wild West again. And so there are arguments on both sides, and I'm not going to get into that. But I will just kind of like go through this quickly. It says the Supreme Court held that when United States District Court tried to ban handguns under the Second Amendment, is unconstitutional under the Second Amendment. The person had applied for a handgun and was denied his request, which cited the strict gun control. Well, in Chicago, they did the same thing, and it was struck down. But we're talking about handguns. Once again, I ask people this: where in the Second Amendment does it refer to historically about handguns? Handguns didn't exist. I'll leave that alone. But the point of the matter is there's all kinds of arguments on both sides. But I will say this to you. Depending on which side you're on, almost is determined by your personal experiences and where you live. If you live in an urban area, you're probably heavily dealing with gun control. If you're living in a suburban area or outside the urban areas, or the country as we call it, or the sticks, or whatever you want to call it, then you start to get into the right to carry guns and stuff like that. So again, it comes down to something that's happened in your family. I know which side I'm on because I had a member of my family who was shot, and she nearly died, but she lived, but someone who was with her died. And then almost every day, you know, those of us who are in the Chicago area, and Dorian knows what I'm talking about, that there's shootings that take place on a regular basis. It's almost like, you know, people were all, wow, what happened in Vegas? Well, that was involving semi-automatic weapons. But there are shootings every day, you know, along I-57. I use a highway that Dorian knows what I'm talking about. In our city, there's always shootings over in that area. But the bottom line is that it depends on where you're from there. So anyway, that's all I'm going to say about that. And then there's the Brady Act, which deals with a law that was established after Jim Brady, the press secretary to Ronald Reagan, was shot in the head, and he remained paralyzed until he passed away. This person, Hinckley, was mentally ill and had a criminal history. And so background checks. Now, there are people actually who oppose background checks. There's also some move that the current president did want to do away with checking the mental capacity, health of people applying for guns, which made me scratch my head on that one. But the point of the matter is that because, again, using the Second Amendment, said that some people argue that the Brady Act is unconstitutional because it allows law enforcement officers to conduct background checks, which they say violates the 10th Amendment, taking one of the rights that individuals have away. And like I said again, I take issue, and a lot of people do. But the Supreme Court did agree to a point, but they said that the statute was overall good. So there's still requirement for background checks and things like that. So now we leave the Second Amendment, we get to the Fifth Amendment. The Fifth Amendment says no person should be deprived of life, liberty, or property without due process. In other words, a fair hearing, notice, and those kind of things. I kind of talked about that, so I'm going to swooze through this pretty fast. And then the laws can be struck down for vagueness, where it's not clear what it is, or it can be overbroad, such as loitering laws or things of that nature that might infringe on the First Amendment rights. Hold on a minute here as we go through some examples here. Here in 1971, the Supreme Court had an ordinance that stated it's a crime for 3 or more persons to assemble on the sidewalks and conduct themselves in a manner annoying to persons. Now, think about this. Annoying to persons passing by. Well, the court said something that jumps up at you. The court says, basically, what's annoying to one might not be annoying to another, but stated that the law was vague because it wasn't clear, and it was overly broad because men of average intelligence have to guess at it. The law should not be where you have to guess at it. It should be clear what it means, and it should apply in a objective fashion so that it's fair to everyone. And then this one here, I know about this one. Let's see, did I jump it? No, I didn't. It's another one. I thought it was in here. I thought it was this one coming after this. But anyway, self-incrimination says that no person shall be compelled to testify against themselves. You have a right not to testify. You have a right to remain silent. People know about that because of the famous Miranda case. But it limits the degree to which the states can pass laws that require people to report information that can place them in jeopardy. In other words, make you incriminate yourself by a reporting requirement. Let me give you an idea of what I was talking about. Oh, the case that I was thinking about, I thought it was in this class, but I think it was in my other class that I teach, or it might be in other weeks. But the point of the matter is that there was a case in Illinois, in Chicago particularly, that had an ordinance similar to the one in Cincinnati, and it was struck down because the purpose of the law was to try to get at gang activity. But because it was written almost the same way as that Cincinnati, it was struck down because of the fact that it violated the First Amendment rights of individuals. It presumed that people were up to no good. But anyway, here's the one that deals with self-conviction. Timothy Leary was what we call him, a doctor, a drug doctor. There's an old movie called Hair, and they sing, and they have the song Hair, and they talk about Timothy Leary Deary. Well, he was a scientist, a chemist, a doctor who, anyway, dealt with all kinds of drugs. Anyway, the Supreme Court reversed the conviction of Leary because there was what they called the Marijuana Tax Act. Now, the Marijuana Tax Act required that if you were distributing or using marijuana on a high level, that you had to file a report to claim the taxes on it. Well, the court says no, that violates his Fifth Amendment right, makes him incriminate himself, and if he doesn't file it, he's going to violate the law. So the court said that the marijuana tax effectively required Leary to identify himself as a criminal, since possession of marijuana was unlawful in every state at that time. So it went away. It went away. This is in 1969. That was the year I graduated from high school, and that was a heavy time about drugs and PCP and all that kind of stuff. Prohibition against cruel and unusual punishment. We will talk about the Eighth Amendment. Applies to both procedural and substance of the law, and often applies to challenges to the death penalty. I mentioned that earlier, and can be employed to limit the definitions of crime, such as Rasmussen versus California, which struck down a law that made it a crime to be addicted to narcotics. It is not illegal to be addicted to narcotics. What is illegal is to be in possession of the narcotics and be arrested with the narcotics. But who's going to have it? Sellers and people who are addicted to it. So therefore, you can prosecute a person for that, but not just because they're addicted to narcotics. That's a status. Death penalty for juveniles, I mentioned this earlier. This settled it once and for all. Roper versus Simons, that the execution of juvenile offenders violates the cruel and unusual punishment of the Eighth Amendment. Two of the justices, Scalia, who's passed away and been replaced, and Thomas, not one of my favorite justices, Clarence Thomas, dissented, saying that the court shouldn't be legislating from the bench. The point of the matter is juveniles cannot be executed unless you're 18 years or over. Okay. There's a right to privacy. The sphere of intimate personal conduct is immune from legislative interference. In other words, the government can't come into your private area, your bedroom. And it relies on the Ninth Amendment that says the enumeration in the Constitution of rights shall not be construed to deny or disparage rights by the people. In the Griswold case, by the way, the Griswold case is not about Clark Griswold, Chevy Chase. It was actually a case that is coming up now, Griswold versus Connecticut, a 1965 case that had to do with contraceptive devices. In this case, the Supreme Court struck down a law that was on the books in Connecticut, stating that it violated the constitutional guarantee of marital privacy. So it meant that individuals were no longer able to be convicted for aiding and abetting individuals who were married from the use of contraceptives. So prior to that, you could, but the court said no, and that's a precedent that still stands. Then they extended it in the Eisenstadt case, which is next, Eisenstadt case, to the same unmarried persons. So it doesn't matter whether you're married or unmarried persons with contraceptives and contraceptives foams. The government can't infringe upon that as well. Abortion, I'm not going to get into that, but the Roe v. Wade issue is an argument that came from '73. It's up in the air. There are challenges now to it. In our state, Illinois, the governor just signed a law into saying that even if Roe v. Wade is overturned, that as a state, they will still protect women and allow abortions under probably some stair steps like Roe v. Wade. And so the freedom of access to clinics protects those who seek or perform abortions from individuals who don't, the right to life people, from barring them from entry. And then Roe v. Wade, I'm not going to go into the details of that. And then abortion, pro-rights versus pro-choice versus pro-life. Okay, after Roe v. Wade and Griswold, the privacy continued. and now it said provided prerequisites for gay, lesbian, and bisexual movement, but it was not until 2003 that the Supreme Court recognized the privacy rights of gay and lesbian in Lawrence versus Texas. But of course, we know that has changed totally with the Supreme Court decisions and the legislation that's on the books now. Lawrence versus Texas says that the government may not criminalize adult sexual conduct. Okay, and so now all of that has changed because of the way the laws are right now. Right to die, the Sarah Quinlan case, in other words, a person can decline medical treatment, but the question of whether the family has power to make a decision is still up for debate, the right to die and the equal protection of the individuals themselves to make that decision. That's what that's all about. A lot of people have DNRs, do not resuscitate when a person gets sick, and that determines that if something happens that there is no resuscitation attempt. And we're almost done here with this, is that the 14th Amendment applies equally to all people. And then the Due Process Clause of the 5th Amendment, and I already gave these cases. I already talked about Loving versus Virginia, and that is actually right here. Can't get it to click. There it is. And I already talked about that case a little earlier, interracial marriage. And then there are different tests that the court has for studying cases to determine whether or not a case is constitutional. The rational basis test must be related to, the government must have a real legitimate interest. The strict scrutiny test applies primarily to First Amendments because we want to favor First Amendments. And then there's a compelling interest test, which means that the government has an interest strong enough to override that First Amendment or fundamental right. Okay, each state has a right to his own constitution and laws as long as it doesn't affect or conflict with the federal government. And that's it. It's a little bit after. It's 10:03. I'm not going to go over parties of crimes. And you know, as I explained to students, I have two choices. And I already have asked students, and I didn't ask this group yet, but I know what people are going to say based on my experience, is that if I eliminated the first half an hour of going over the assignments for the week, then I'd be able to do both. But students have said, no, I like the fact that, you know, it operates that way. So anyway, like Brenna, she has to go to bed 4:30. She has to be up early. So anyway, I understand. That's why. So we're going to end right now. So I'm going to say good night to everybody. Any questions? No questions? Okay. So I'm just going to say good night, and you know how to reach me if you need me. Okay, good night, and I'm going to go back, and I am going to end the meeting.